Trials are inherently inefficient. Presenting raw evidence, authenticating documents, and examining witnesses in open court consumes massive amounts of judicial time. Before a judge even hears the first witness, the issues must be ruthlessly narrowed down to only the facts actually in dispute. In Philippine remedial law, Rule 26, admission by adverse party, is the precise mechanism designed to force those pretrial concessions. For bar examinees, this rule is a recurring obstacle. Examiners heavily test Rule 26 because its simple premise hides highly specific procedural tripwires that can instantly collapse a case. Specifically, the rule establishes two primary consequences: the implied admission, which deems a fact true by default, and the evidentiary bar, which blocks a party from presenting evidence at trial. Looking at this timeline of a civil action, we can see the precise chronological window for this tool. A Rule 26 request can only be deployed after the joinder of issues and before the trial begins. We will deconstruct sections 1 through 5 of Rule 26 to map the mechanical requirements of a valid request, the strict deadlines, and the consequences of ignoring them. Mastering Rule 26 makes discovery a mechanism for securing binding pretrial concessions. Section 1 initiates the process. Once the issues are joined, a party files a written request to clarify any vague allegations left hanging in the pleadings. The rule restricts this request to two specific targets: admitting the genuineness of a material document or admitting the truth of a material fact. A valid request seeks new clarity to expedite the trial. An invalid request simply repeats allegations the opposing party has already expressly traversed. If a defendant has already firmly denied forgery in their verified answer, sending a Rule 26 request asking them to admit the document is forged achieves nothing. The fact is already controverted. This maps the critical procedural requirement for service. The request must be served directly upon the requested party, bypassing their counsel. Serving the request solely upon the opponent's counsel is fatal. As shown, this routing stops at the counsel node, rendering the request unenforceable. An improperly served or overly redundant request disarms the mechanism. The statutory clock will not begin to tick, and no implied admission will be triggered. Section 2 establishes the mechanism for the implied admission. Upon receiving a valid request, the adverse party is placed on a strict countdown. They have a designated period of no less than 15 calendar days to submit their response. The response must be a sworn statement. The party must either specifically deny the matters or set forth detailed reasons why they cannot truthfully admit or deny them. Examiners consistently test a specific variation of the scenario known as the unsworn trap. This logic comparison illustrates the trap. An unsworn denial produces zero legal effect. Without the oath, it is legally treated as silence, causing an implied admission. Only submitting formal objections to the court halts the countdown, deferring compliance until the judge resolves the objection. Once an implied admission is triggered, the tactical landscape of the case shifts instantly. Because the requested facts are now legally undisputed, the requesting party can bypass the trial entirely by filing a motion for summary judgment or a judgment on the pleadings. Under Section 2, a missed deadline or a missing notary stamp rewrites the uncontested facts of the case, highly favoring the requesting party. To encourage litigants to use discovery freely without fear of mass self-incrimination, Section 3 creates a strict jurisdictional firewall around these admissions. The core concept is summarized by the mnemonic PAO, pending action only. An admission made under Rule 26 lives and dies within the specific docket number where requested. It cannot be extracted and used against the admitting party in any other proceeding. This leads to the classic BP 22 crossover found in bar exams. Consider a scenario where a defendant fails to answer a request and impliedly admits to signing a bounced check in a civil collection case. If that same defendant faces criminal charges for that bounced check under BP 22, the prosecutor is legally barred from introducing the civil admission to prove criminal liability. If opposing counsel attempts to offer that admission in a different trial, the required response is immediate objection. The rule explicitly forbids cross-jurisdictional use. The PAO rule guarantees that an admission functions strictly as a tactical surrender for one specific battle, avoiding a universal confession of guilt. Section 4 provides the sole equitable escape hatch for a litigant caught in an implied admission. When the 15-day period lapses without a sworn answer, examinees often assume the remedy is simply to file a late answer. This is a procedurally invalid response that will be struck down. The correct procedural remedy is to file a formal motion asking the court to withdraw or amend the implied admission. This mechanism relies heavily on the broader principle of remedial law, the liberal construction of procedural rules to prevent a failure of justice. Courts generally prefer deciding cases on their substantive merits. They possess the discretionary power to lift the admission if there is good cause shown. While an implied admission creates a devastating presumption against the client, a proactive lawyer can shatter it by successfully invoking the court's equitable discretion. Section 5 shifts the focus entirely. While the previous sections trap the defending party, this section levies a severe penalty against the requesting party. The rule dictates that if a party fails to file a request for admission regarding material facts that are within the opponent's personal knowledge, they trigger a self-inflicted penalty. This logic tree maps the outcome at trial. If a lawyer fails to file the request, they hit the evidentiary block. They are completely barred from presenting evidence regarding those specific unrequested facts. The penalty is highly conditional. It only applies if the unrequested fact was actually within the personal knowledge of the adverse party. If the fact was known exclusively by a third-party witness, the bar does not apply. Much like the withdrawal of an admission, the court retains the power to relax this evidentiary block for good cause shown, ensuring that a technical failure does not result in a total failure of justice. This exposes the bilateral architecture of Rule 26. Section 2 punishes the requested party for a failure to answer. Section 5 punishes the requesting party for a failure to ask. Trial preparation requires strict adherence to these mechanics, calculating the 15-day limit, securing the sworn statement, understanding PAO containment, and executing direct service upon the party. In remedial law, knowing the facts is irrelevant if a lawyer fails to comply with the procedural rules necessary to admit them into the record.